speakers, leaving time at the end for questions and reflections from everyone on the call here. And then just a quick reminder of the chat. We'll keep an eye on the chat for your comments, questions. They can go in there as well. And we encourage engagement both vocally and through the chat. So with that, we'll get started with our first speaker, José Luis Nunes. Hi, José, and welcome to the call. José is an assistant professor. I'll just give a quick introduction.
Could I just not first because okay, so could I just ask for me to be the second person to speak because I had some trouble with syncing the presentation. I'm downloading it right now on the notebook.
Okay. Not a problem at all. Okay, Smriti, would you mind going first? Is that okay? Yeah, great. Okay. So I'll just give a quick bio. Smriti is a lawyer and public policy researcher. She's currently a fellow at the CyberBRICS Project at FGV Law School in Brazil and a PhD candidate at IIT Delhi School of Public Policy. She recently edited the book Private and Controversial that explores the intersection between privacy and public health in India, and will be talking to us about public policy development through that lens. So Smriti, thank you again for being here, and over to you.
Thank you. Thanks so much to you and to the entire team at ODC for having me over in this session. It's a pleasure to be here with everyone. Just give me a moment. I want to share my screen. I have a few slides to navigate the discussion. I hope you can all see that.
Yes.
Perfect. So what I'll be talking about in the next few minutes is just set the landscape for the rest of our conversation about, as I was introduced, I'm a researcher based in India, and my interventions will be about some of the policy developments in India and how they're, working at this intersection of open data and privacy. So just to set the landscape first, I'm going to spend a minute or two talking about the policy framework as it exists, and as it's being envisaged, there are some initiatives that are still work in progress. And from there, I'll transition to talking a little bit about technical architectures that are already being rolled out. So I want to talk both about the law as it exists and is being thought about, but as well as some of the technical aspects of architectures that are taking place, sometimes outside the specific framework of law. So in terms of policy framework, specifically on the creation of data and generation of data and putting it out in the public domain, we have a law, like many countries, which is the Right to Information Act, which is this obligation which, on the state authorities and public agencies to put data out at the request of individuals, but also on a suo motu basis, they're supposed to put out information. And there is an interesting exception there, which, often exists in many such laws about a privacy disclaimer. So if there is a piece of information that is being sought, but that might infringe on the privacy of another person, the current provision says that there is a balancing that has to be taken into account. And unless there is an overriding public interest, you will not disclose that particular piece of information. And I'll talk about how the new data protection law that's been thought about in India is trying to change that balance. But beyond that, we have a policy document called the National Data Sharing and Accessibility Policy. And this is really the main policy from which the open data obligation for the government agencies comes into being. So this is a policy that was adopted in 2012. Just note that this is a policy and not a legislative framework. But what it mandated was that whenever the government has sets of data, or where there is government funding as a result of which data is being created, there should be an effort to put that out in the public domain in a manner which is easily accessible, shareable, in a clean sort of format, which is ready for others to do further analysis and research based on that. And drawing from this policy, we have a portal, which is the government's open data portal that has been created, which over the years has expanded and been populated with a fair number of data sets. And finally, on the privacy part of it, what we have right now is just one provision in the Information Technology Act, which talks about data protection related principles. And out of that, there is a set of rules that have come about for the protection of specific personal data, and specifically in the context of security safeguards around this data. We still do not have an overriding framework on personal data protection like many other jurisdictions have already evolved. That's a conversation that's been going on in India for about I would say at least 10 years more aggressively over the past 5 to 6 years. And we have a draft of a bill which is currently in the process of being introduced in Parliament. So it's going to be a gap, another few years, months. We don't know, because this conversation, as I said, has been going on for a while. But one interesting thing to note in the context of this intersection between open data and privacy is that this new bill tries to amend the Right to Information Act to say that, as I explained, there is currently this balancing principle that unless there is an overriding public interest, you won't share that data. And this bill tries to remove that qualifier. So it just says that if there is any personal information, you will not be obliged to share. And that many of us think might be taking things too far, because, there is, as was said in the introduction, there is this possible tussle that a lot of people see between open data and privacy. But if you set it out explicitly in the law, and give people the discretion to determine whether or not, they feel like there is personal information involved, that could be too broad a set, and that could restrict the right to information in ways which are not desirable. But that's still, we don't need to know whether that's going to be introduced or passed in the current form as the bill goes through the parliamentary process. But I just wanted to highlight that. And beyond personal data, there is this policy framework that is evolving in India around the regulation of non-personal data. So data which was, never pertaining to individuals in the first place, like climate-related data, for instance, or data which was personal but was made non-personal through processes of anonymization. And there is policy thinking. There's a committee which the government set up, which made recommendations about a whole regulatory framework about taking some of this data which entities have today and removing it from these silos and creating a process through which other entities can demand that data. And while maintaining the privacy of it, because it will all be non-personal or anonymized data. And specifically at the level of the government, there is a policy framework that was put out for consultation, and from government reports, it's believed that it's already in the process of being built, which is this database or a centralized repository of non-personal data held with government agencies. So the repository, to be clearer, is not that the data will all be centralized. It will be held with different government agencies, whoever produces that data, but each of them will have the ability to call that data. So if there is some policy making happening, there will be the ability for one government agency to tell another, hey, you have this mobility related data or this, air quality related data. Can you pass it to me in a manner which is interoperable, shareable? So there are these standards which are being formulated to facilitate. So all of this is, you would realize there is some sort of gatekeeping involved. So it's not open data in the sense where we, talk about open data principle, where it's already shareable, open, etc. But it is kind of moving towards that in the sense that it's better than the current system where there is very little data, or the data that's held is, locked in silos. So moving from that into, the little bit about the technical architecture. So in India, for those of you who don't know the background and context, I just want to say that over the last few years, we've seen this trend of the development of a number of technical architectures. And this has come together in what is, popularly in India known as the India Stack framework. And there are several layers which have been created. I'm not going to go into all of these. The one which is relevant for us right now for this discussion is the consent layer. It's about data management and the creation of an electronic consent management framework, where when data sharing takes place, personal data of an individual is shared from one entity to the other. A new layer or a new mechanism for consent management is being created. And let me just explain that through this document, which is taken from a government document. So this is an example from the financial sector. So this whole framework is called the Data Empowerment and Protection Architecture, or DEPA. And as you will see from the illustration, the idea is that there is a user in the middle. Today, if I have my credit information, which is held probably with my bank, and I want to pass it on to, say, an insurance company in order to prove my credit worthiness, what I have to do is authorize the bank, either take that data myself from the bank and transfer it to the insurance company. This is a mechanism which has been envisaged to automate that process with the consent of the user. So a new class of intermediaries called consent managers have been created. So the user, instead of dealing with these multiple entities, will authorize the consent manager to take data from this entity and pass it on to the other entity, while the consent manager itself remains blind to the data. So this will be encrypted data, and the consent manager's only job is to make sure that there are verifiable records of this data, which is authenticated based on user consent. So there will be logs of this whole transaction. The idea of it is to facilitate data transfer, but also to do it in a way which creates authentication logs and makes it verifiable. So tomorrow, when the user is questioned whether you gave consent, there is a way to say, yes, I gave granular consent to give these 3 months of data for this entity and to remove that access after 3 months, for instance. So it can be really granular and specific, and the record of that will be maintained in future if you want to question whether or not consent was validly obtained. So that's a framework that's already been rolled out in the financial sector through a specific set of regulations, first in banking and now is expanding to other layers such as insurance, securities, etc. But it's also being experimented and thought about in other sectors. And I just want to say a little bit about one such example in the health sector. So, as in many parts of the world, post-COVID and during COVID, the digitization of the health sector really became something sort of a priority for governments, and that happened in India too. And what we saw was the pushing of this new architecture called India's Digital Health Mission, the Ayushman Bharat Digital Health Mission, where a set of digital IDs are health IDs. We already have digital IDs, but a separate set of health IDs, often linked to the national digital ID, are being created, both for individuals as well as for practitioners. So the idea is today, my medical records are locked with the doctor or the hospital that I tend to visit. And if I go to a different city and to a different hospital, there isn't easy portability of that data. So relying on the consent architecture that I just defined, the idea is that I should be able to demand that my doctor automatically transfer all of my health records onto this new, new hospital that I want to visit in another city, and to do all of this in a manner which is, with my consent, but also protects the data at the same time, and through the use of this intermediary called consent managers. But coming specifically to our conversation today, beyond consent, there are possibilities of data sharing. So there is a provision which talks about anonymized or de-identified data being shared in an aggregate form for reasons which are not specific to my health records or my health management. It could be for research purposes, both clinical research as well as academic research, for statistical analysis, for policy formulation. So again, this is not open data in the sense of being truly open, but there will be this ability for these entities, as long as they can prove that this is de-identified and anonymized and cannot be easily re-identified, there is this possibility. But it's just important to note that the policy document also says it could be for any other purpose. So right now it seems like it's a very research and development and policy oriented purpose, but tomorrow, if this could expand to include commercial purposes, for instance, we don't know. That's a possibility that the government has held in its own hand. And just to note that this whole framework has come about again through a policy document and not through a specific legislative instrument. So amending it is fairly easy for the executive. It's not something which will go to the parliament in order to change this list of purposes which can come about. So I just want to sum up with that, from what I described, you would note that there is this fairly sophisticated and elaborate suite of ideas and digital architectures that India has evolved. But I just want to emphasize that the emphasis has been on, regulating through architectures as opposed to regulating through legal instruments, laws, regulations, etc. And that, of course, if you think about it from a rights perspective, comes with certain concerns, because that these are instruments which can be modified fairly easily with less accountability. And just the final comment that all of this needs to be taken into account with the context that we are talking about, that we're talking about a country which is rapidly digitizing, but still it's not fully digital, both in terms of access to the internet, but also in terms of digital skills. And, we saw varying level of that through digital access during the pandemic. There are implementation reality. There might be great ideas, which some of these visionaries come up with. But when it comes to implementation on the ground, there are street level bureaucrats who are involved in the process, and there are gaps which have been experienced, across the projects which I described. And finally, the absence of a legal framework, although we do have a constitutional protection of a right to privacy, the absence of a statutory framework does complicate the implementation of many of these ideas from a legal, point of view. So thank you so much. And these are the resources. I've shared the presentation. I'm happy to share the resources on chat also, based on, this is my comments were pretty much based on some of these articles and the book itself. So thank you.
Wonderful. Thank you so much, Smriti. That was fascinating. The things that stood out to me was first setting the landscape, like you mentioned at the opening, in terms of talking about the modernization of right to information acts and how that comes to play here. And then talking about at the end, the digital divide and how that also has to be a factor and how we can use sort of this new governance of technical architecture to build trust as opposed to focusing on compliance. Hopefully we get to talk about that a little bit more at the end. But for now, we'll move on to our second speaker. Tomas, if we can go to you, that's okay, if that's okay. Wonderful.
Hi, Wilfred. How are you?
I am doing well. Hi.
Hi. Well, first of all, thank you very much for having me in here. And I would like to share our experience here in Argentina. I do not have a presentation, but I would like to share with you some links. I have them on English with you, because, give me 1 second. Here you have one. And there we go with the other one. This may sound strange, but I would like to address the issue of open data and privacy protection when it comes down to public policies, and especially to what we were having here in Buenos Aires, that it was a facial recognition system that was being run on public spaces. Yes, this may sound strange, but this was a huge case on the last year here in Buenos Aires. There was a case that was led by O.D.I.A, my organization, where we do strategic litigation regarding the use of new technologies by the government. Why I would like to address this? Because most of the times when we talk about open data, something that we are not, maybe I have the feeling we do not take into account, is that it's not only about opening information. Most of the times, we need to have certain accountability regarding that information. And we also we do not only need to open the information, if not that we need a proper investment by the governments just for taking care of that data and being sure that data is an adequate one. Yes, I'm going to share a small image. Give me a second, please. Just 1 second. I'm going. Sorry, I need 1 second for this because I'm not able to find the presentation. Oh,
no problem, it's okay.
Give me 1 minute, sorry. Because I would like to explain to everyone here how the facial recognition system was running in Buenos Aires, and this may sound abstract to most of the people. So I have a little picture for showing how the databases were working together. Just 1 sec. Yes. Okay, so now you can see it, no? Okay,
yes, we can see perfectly.
I mean, this is in Spanish, but I think it's quite easy, no? So here we have, like, on this red square, that was the police station in Buenos Aires. And there you have the number one, the first step. The police station CMU was asking to open data held by the Justice Minister, called CONARC, for the names and the national ID numbers of all the people which was required by justice, no? Afterwards, the police was taking this, they were taking this information and they were asking for the facial recognition information that is held by what we call RENAPER. That's that's a part of our interior minister, that is the one that gives you the national ID that has your picture, yeah? And once they were getting these pictures, once the police was having those pictures, they were all using certain facial recognition technology for having this kind of map of your face, you know, and they were running this on the streets, and they were like picking up people on the streets and taking them to jail and everything. Why this has something to do with privacy protection and open data? On the first year when they were using this technology, a major issue that came to public knowledge was that the open data that was held by CONARC was really bad. I mean, they were having lots of typos. Just for giving you an example, I send you another link that was a report made by the Privacy Protection Special Rapporteur from the UN, that he came to Argentina to see what was going on with this. And he discovered that on this open database held by the national government called CONARC, they were running the information of kids who were under 10 years old, and they were supposedly being looked for robbery using guns or something like that. No, so the database was really broken. No, and this is something really severe what happened here, because that broken database, that was an open database, that they just opened it and they didn't put not even $1 for making sure that the database was a proper one, and they didn't have any professional taking care of that information. That on the end, after the information was received by the police, that bad information, that meant that they were running facial recognition technology on the faces of 5-year-old kids or 7-year-old kids. And they were like, after putting done to work on the cameras for recognizing people. That has a lot to do not only with private protection and with protecting the people on the streets, because there were lots of false positives and there were lots of facial biases and all the problems we know we are having with facial recognition technologies. No? But what I would like to address with this example of Buenos Aires is that when it comes down to data protection, and when it comes down to open data, something very important is not only having a legal framework for opening the information held by the governments. We also are requiring our governments to put money into it. We need to have a proper policy for taking care of this information and making sure that that information is not going to affect another jurisdiction that may be using that technology for developing a different public policy. No? In this case, I think that what happened here, all this case in Buenos Aires was something very hype by the media, because all the case really escalated quickly, and it wasn't only about when we started this demand, we were like demanding the government because of racial biases and all the classical problems regarding facial recognition systems, and suddenly the whole thing escalated very quickly to, for example, public attractions and certain spy issues that they were like, people was accused of spying and other ones. But what I would really like to address is the problem that when we think about data protection and open data policies, we have to take into account that what we call open data is now, for us, is like databases that are used by other governments or other parts of our society for developing different kinds of public policies. In this case, what happened was that when the justice minister decided to open what we call CONARC, this orange square here, they didn't take into account the need of having a proper guidance or having certain policy for opening that information and for making sure that that information was a quality one. So, and that ended up with a huge problem for the city of Buenos Aires government. The court decision is now, we already won the case. The facial recognition system has been unplugged here. And one very important part of all this work was just proving to the judges that the databases that they were using were absolutely broken. No. So for this, I just wanted to share this experience. I show you the links of what happened here, just for making sure to everyone that when we are talking about open data, it's not, nowadays, it's not only about transparency, it's much more. When we take into account the use of new technologies, the databases that are being open are a very substantial part of new public policies held by the governments. So that's, I don't know if anyone has any question about this.
Perfect. Thank you so much, Tomas. Well, if we can hold the questions till the end for the Q&A session, we'll dive into them then. But again, thank you for that overview. I think we hear a lot of people say garbage in, garbage out when it comes to talking about data. And this is a really great example of the tremendous implications of that when we talk about data quality. It also touches on some of the other themes we've talked about this year already around the importance of data governance and the role of AI in open data. So yeah, I think that was an excellent conversation. Thank you so much. With that, we'll move to our last speaker, but certainly not least. Jose, hopefully is that okay that you're ready to go? Great. Okay, so I'll give your bio quickly. Jose Luis Nunes is an assistant professor at Getúlio Vargas Foundation School of Law in Rio de Janeiro, a researcher at the Center for Technology and Society, as well as a master's and PhD student in informatics at PUC Rio. Jose, the virtual floor is yours, and thank you again for being here.
Thank you very much for having me. Can you hear me well? And can you see my presentation? Yes?
We can
That's
hear
perfect.
you well. I don't see the presentation yet, but I think it's coming.
Your screen share is paused. Okay. Resume share is not. Let me share again. See if it fixes it. Okay.
There we go. We see it.
Okay, that's perfect. Okay, so thank you. So what I hope to present in this time is a quick summary of a larger and hopefully more robust report that we've worked on at CCS with the help of a lot of people. So I'm only one of the authors of this broader research. And it focuses on data governance for sustainable digital transformation. And we also focus on the public sector, and we deal with open data and personal data. So hopefully we can have some reflection combining what Tomas just told us about. Maybe it will be helpful. So going forward, we did some research. So we made some we research using federal laws, state laws, and federal regulation, and public recommendations and industry and academia best practice on 3 topics. So we analyze open data, personal data protection, and cybersecurity, regulation, and best practice in these 3 areas across Brazil. So this was mainly at federal level and state level. We mostly didn't look at municipal level because that would be like we have a lot of cities in Brazil, so that would be a very larger and rather effort. And we try to compile recommendations plus provide a model for digital transformation and to deal with this different areas in somehow more integrated way. At the end, I'll focus at this general recommendations plus the model. So I will not go through each of these areas recommendations due to the time constraints. And the current data structure and the CRs work mostly separate right now in Brazil. So we have legal stipulations for municipalities, states to have a data protection office, transparency office focused on opening data, and a cybersecurity office. And each of these will have a legal person which is legally responsible for answering requests and dealing with the day-to-day operations of the public sector. And I think one of the main recommendations is that there should be an integrated structure between these 3 areas where people from each of these spaces could share information and take decision-making in an integrated way, while also receiving input from other sectors and from other stakeholders. So as general recommendations, this structure should include members from all public interested offices, as well as representatives from other stakeholders such as civil societies and academia, so specialists, and it should provide effective transparency on all data governance structure and decisions. So this could be done, for instance, such as through regular auditing and making public data processing that is carried through government. Third thing is promote social participation. So conduct public biddings and public consulting or other process for society to be able to participate in policy making, as well as setting the agenda, for example, on what database should be made public, what's your opinion, what restrictions should the government take for this, what security measures should be taken, and as well as publishing studies of impact on data protection of this eventual process of opening data, possible impacts of data security, and in general, evaluating risk of all public actions regarding data and digital transformation. As well, it should be in charge of defining guidelines that could be used and applied by all the government structure. So it would be in charge of setting an agenda and best practice within that organization, public organization. For example, trying to define guidelines on what techniques used to remove personal information from data that might be published or processed, such as anonymization or pseudo-anonymization, depending on the case or on the relevance of the data. And another important recommendation that we do put forward is the implementation of research sandboxes. So creating some sort of space, figuratively speaking, where researchers or people interested in using the public data could, with established restriction, could use this data and try to implement a certain research, develop certain tools with constraints, trying to protect the data. And none of these results or potential products would be made public, would be published without following authorization from the government. So this would try to allow for more innovation and development of new solutions based on data, while also attending for cybersecurity and personal data protection matters. So they would serve as kind of data havens, which are heavily controlled. So they have access control, control which data is made available for researchers that are using it. And most importantly, what can be made public following this process. So this is kind of, these are kind of the 5 pillars. So this aspect should be taken as precautions. So guaranteeing that users which attend to this sandboxes are safe, the projects allowed to be developed as safe, or whatever data or product that is published afterward has been vetted by the public institution. The data is made safe through anonymization or removing personal data, as well as the place. So be it virtual or physical, the place where the sandbox is being carried and people are using the data is in a safe setting. So in general, this would make a structure that would integrate this 3 offices per se. And from that, we also suggest a model for impact evaluation of opening data. So for any process that of opening data, which takes into account privacy concerns, as well as data security concerns, cybersecurity concerns. And we believe this model provides a general view of, should provide a general view of the data treatment that is being carried out. So we a specific document for any project of opening data of any treatment that's being carried out. And it's specifically proposed in our document. It could provide transparency and control of all treatment operations being carried out through the public sector. And it would register this information and made it easily available and consultable to anyone interested. It would promote actions to mitigate risks. So if you're taking treatments or making data publicly available, through its structure, it would promote measures to mitigate this risk of identification, especially so if we're talking about personal data or some sort of leakage, leaking any sort of data concerning cybersecurity or other vulnerabilities that might be carried through. And as well, evaluate possible privacy violations. So in addition to carrying risk mitigation measures, the responsible office should also evaluate what are the risks and outcomes that might be possible with these violations, be it to privacy or to security. It could also be used to validate any data sharing that can be carried with third parties. So if the public sector is sharing any data with a specific research institution or a company to develop any product or solution for public policy, it should be registered and carried through using the model. And another important aspect is that this document would help to standardize decision-making and aid the process for the data, whoever is in charge of all this handling the digital transformation. So right now we have like a kind of 3 different figures, one for cybersecurity, one for opening data, and another one for data protection. So with this integrated infrastructure, you help a decision making for these three figures that we believe should be somehow integrated in a same structure, which would allow experience and a better decision making that considers and tends to all these three areas in the public sector. So thank you very much. So this is in general what we prepared.
Thank you so much, Jose. That was great. I really like the progression that you laid out from data governance to implementation to evaluation and impact assessment to understand how we can work on risk mitigation and reduce, those threats that you talked about, cybersecurity leaks and so on. So that was excellent. Thank you very much. So with that, we'll open up the floor now for your questions. And if you don't have a question, you can also put your hand up to share what you've been working on in this space. I think I didn't see anything in the chat, but Mechi, please let me know if there are any questions there.
No, it's not any question in the chat, but I think that we have a lot of people with experience here. Tomas, yeah, go ahead.
Yes, sorry, I have a question for Smriti. I think I pronounced it properly. I was hearing to you and I was really surprised to see that what you were talking about, the India's health project, like this decentralized health. And I have a question regarding what's going on in India with cybersecurity. Is there any special program or framework for protecting data or like having something like what we call structural sensitive infrastructure, or how are you working with that issue? Because here in Argentina, some years ago, they tried to do something similar, but we are having such a huge problem with cybersecurity here. So that's a huge wall we have for working with that. So how do you deal with that issue in India? I'm seriously intrigued by that, sorry.
Yeah, thank you for that. And as you explained in the situation in Argentina, it's very similar in India. There has been a spike in cyber incidents, certainly during and after the pandemic. And in fact, very recently, the largest public hospital in India was subject to a cyber attack where the whole system was taken down for a number of days. Everything had been converted to digital, but for a number of days, the digital system was down and you had to convert to manual. So you can imagine this is a hospital seeing 10,000 people per day, and suddenly you're in this kind of chaos. So it is true that our digital cybersecurity frameworks have not kept pace with the kind of pace of digitization. So there's a lot of adoption. People are being thrown in the deep end without thinking both about privacy as well as cybersecurity aspects. Having said that, we do have certain sectors which are designated in the law as critical information infrastructure. So health being one of them, but power, energy, financial sector, etc. So there is specialized frameworks for notifying when a threat takes place. There is a focus on these sectors. And just today I read recently that there is a news about taking this to the next level, and we've had talks about bringing about a new cybersecurity policy. But in terms of a legal framework, we are really lagging both in terms of implementation and law. Cybersecurity is not received the focus it should.
Thank you very much. I would really like to know what's going on with cybersecurity in India. That would be great. I'm going to be looking for that new legal framework or new program. Thank you very much.
Yeah, I'm happy to share some links when the new policy is announced.
Christian, I see your hand up.
Yeah, yep. Hi, yeah, I guess this question is for Tomas. If you could speak a little bit more about the process of strategic litigation that you went through. I'm just very curious to see what legal frameworks you relied on. Just thinking of the balance with international law and like regional mechanisms like the Inter-American Court of Human Rights, and kind of like which way you guys decided to go on that. I know it's a little out of the context.
No, thank you very much for the question. I mean, just for being clear, here in Latin America, something very important is all our international jurisprudence regarding access to public information. According to our Human Rights Court, it's supposed to be an essential part of your freedom of speech. So this this core decision, the first part of this strategy was like doing several access to public information. That is something that you can require to the government, and afterward you can require it. You can take the government to the courts. No, a very, I will not say funny, but well, it's kind of funny part of all these kind of systems like facial recognition and all those kind of technologies is that they usually use a lot of databases, different databases. So they depend on different parts of the government, or even in different kinds of government, because they're using federal information for a local government usage. No, you're having that kind of problems. So a very important first step we took towards this issue was doing a lot of requirements for public information regarding what technology they were using and how they were like distributing or securing the information, all that. The things that they were like replying different answers to the same question, because the system was held by different parts of the government. You were having the police, the justice minister, then you were having the public defendants that they should be like controlling the whole technology. So the first part was doing something like that, and we got to our first conclusion that was that no one is controlling the usage of this technology. And something that really helped us was when the special rapporteur for private protection came to Argentina. He was allowed to see the databases, and he realized that the databases they were using, that they were just open on 2019. This is important. They were open only for 2 years at that time. They were absolutely broken. And that was something that I would really like to point out, because usually when you talk with people working in opening data and all that in the government, it's only about opening the information and that's it. And no one is like putting attention to, hey, how do you open information? You should pay people to take care of this information, to be sure that the information is adequate and all that. So that was a huge part. And afterwards, we went to the city of Buenos Aires judges and we started there. But it took us less than 3 years to unplug the system. It wasn't so long. I don't know if this
yeah, just a follow up. So so within like national laws of Argentina that you guys operated in and didn't like have to rely on international law or jurisprudence, or?
Well, that's the thing went this way. At the beginning, when we sued the government, we were like suing the usage of this technology because of racial biases. That's a huge problem when it comes down to the usage of facial recognition systems. To sum up, especially because it's a kind of artificial intelligence that use different kinds of databases, and you do not never get to know what kind of databases they were using to train the models. You don't know, I mean, if they were using like faces from different racial groups and all that, you know? As the company is a private one, they were not showing their databases. They say this is protected by IAP. So we were not allowed to see which databases they were using. So at the beginning, we were like suing the government because of discrimination issues. That was the point, and the perils that this kind of systems implies because of cybersecurity. You can have someone doing a cyber attack to the system, and maybe someone like looking for someone else on the streets. Summing up, suddenly we discovered there was a lot of monkey business going on with the public money and the contraction, and we held I don't know the word in English for this, allanamiento, you know, like a raid, you know, when you go to the police to take stuff from somewhere. I don't know, sorry, the word for this in English. We held one of those.
Christian speaks Spanish.
Oh, anyway. Sorry.
Pero no sé cómo se dice allanamiento, sí, tampoco.
We don't know, this word in English is kind of difficult, but when you go with the police to take something from somewhere, you know, like we did that with the federal police. We went and we held this raid to the local police. So it was me wearing a suit, I usually wearing a suit, with the federal police going to the local police station, and we took the servers. No, when we took the servers, the whole problem really escalated because there was lots of information. For example, something we proved is that we don't know why, because that's now on a criminal case, that we are not the ones suing no one, because I'm not a criminal lawyer. But we discovered that on the servers, there was facial information from major politicians and social leaders, human rights defendants. So all the things escalated really quickly, and we won by that. But yes, lots of our arguments were based on human rights, preventing discrimination, and all that kind of stuff. But the court decision is now like the city of Buenos Aires didn't appeal because of the scandal. So now it's unplugged, and we already won. I think so.
I'm curious, Tomas. So, what is the future of this work? If you've won the case, it's unplugged. Does it remain unplugged? Is there ongoing work to do it better? What comes next from here?
This has not really much to do with O.D.I.A, but we won the case. The system is unplugged. The funny thing is that I'm gonna try to be honest with this. In Latin America, we are having a huge issue with vendors, technology vendors. It's like people usually go across our continent sending technology to the governments that you don't know where it comes from. You don't know it's under private licenses and all that. So even though we won this case and there was a huge scandal, like nowadays we are having elections this year, and lots of politicians are talking about I'm gonna implement facial recognition systems. So our next step nowadays in O.D.I.A, that's my organization, we are like doing some fundraising now. We are like looking for grants and everything because we want to do a class action against the government because of the usage of this, because we think nowadays it's not only talking about the technology, it's not trying to make the government accountable. And accountable means that they have to pay money for this. There were 7,500 records of people that should not be there. They were scrapping their faces all around the city. We don't know why, we don't know who, we don't know for what. So, I mean, the system is unplugged, but we are still working on how to stop this kind of technology.
Amazing. Thank you.
Thank
Smriti.
you.
Yeah, this is for José, and I actually want to tie it to the question that Larissa posed to everyone, about how do you decide which databases and which data sets to open? And José, in your presentation, one of the things you talked about in the sandbox context, you kept using the word safe, right? All the 5 principles had this word safe. So I'm wondering if in the paper or in your thinking, like how are you thinking about safety? Like in what way are you defining safety? And then to Larissa's question, what are the other kind of principles you would think about?
Okay, so maybe I could give the question to Larissa. Just kidding. So safe, it goes into taking measures. So part of it is through technical measures. So what data is made available, how, and providing a digital environment or a physical facility where the actions could be carried. And part of it is through human and manual control. So evaluating what people should be granted access, what projects should be allowed to be developed, and what information, what reports should be allowed to be made public. So it's an integration of both technical side and manual and human decision making. So each of those I had to summarize very fast, but they go into more detail in the report. But I think that's the idea. So for example, for the users would be mostly a human decision making of who is a trusted person that should be allowed access to the data and to develop any project or any research using. So you have some sort of vetting process for that. On the other hand, you want to make only the data available to that person, which is necessary for his project and the research being developed, as well as guarantee that no personal information that might not be necessary for that specific purpose is not made available. So so this is more on the technical side. So you have to join both sides and try to integrate this into again, safe environment that addresses all these possible issues. And trying to somehow get into the question Larissa posting chat, I think right now there's not really anything that's really cohesive and that addresses this issue as far as I know, and hopefully we can contribute to that effort, especially in Brazil. We're similar to India, as you put in your presentations, Merge. We first had an open data framework, which was developed through many decades and finally some public entities make data available on its own website nowadays. And with the effect of the data protection law, we did see some government pushback to some of the established data that was already being published. So I think it's kind of normal for as this new dimension gets relevance. We still have to find the middle ground where can these things meet and decide, and where's the limit of data protection and where are the limits of data being made public from the government side. So right now, I guess the only concrete answers we have is what has been established by law that should be made public or should not be made public. But from other than that, I think there's no cohesive and established guideline or any normative material on that issue.
Smriti, would you say that's true for the Indian context as well?
Pretty much, that what José just said really resonates, because we've had this really long history of people trying to get accountability from the government. The whole right to information movement was about, so you see a lot of corruption on the ground. How do you make sure that there is information coming out in the public domain? So one of the ways in which, information activists pursue this is by saying, okay, whenever benefits, welfare is being given by the state to the public, we want that information put up so we can really go to these people and verify, did you receive this much ration? Did you receive this food grain? Did you receive this petroleum subsidies, etc.? And in the privacy movement, we are seeing that tension where you don't want this information in the public domain, right? You don't want the full name, the identifiable information of the public, that person in the public domain. So there is this, and there is some conversation between these two communities, but there is this inherent kind of tussle which is taking place. Certainly, I think it cuts across all developing countries' contexts, where you want accountability from the state, but you also don't want the state to, overemphasize that accountability in a way which, rides over people's privacy. And I get it from the state's point of view also, that we are dealing with contexts with very limited state capacity. So, resources are limited, people who are trained, their skills are limited. So in that sense, demanding both transparency and demanding data protection in contexts where people dealing with these don't often understand the value of either, it's a difficult challenge even for the people on the ground who are being tasked to do all of this.
Agreed. Even across, I work for the government of Canada, we have similar challenges. And every time we meet, we sort of hear the same kind of, the same barriers that we're all facing. So it's great that we get to exchange in forums like this. So with that, we have about 5 minutes left, and I do want to take a second to wrap up, but I just want to check in to make sure nobody has any questions before we do. Last call to get some information out of our speakers or to share your own experience on what you've been working on in relation to rights and regulation. Okay. Well, with that, again, thank you, Tomas, José, and Smriti for being here and for contributing your insights from your own experiences. The big takeaway I'm hearing is that open data and privacy are not at odds, that they can be balanced. However, they do need to think through data governance very strategically to be able to do that. Whether we're using legislative frameworks or technical architecture, we have to think through and do these things properly. So thank you again for being here. Just a quick reminder that we are off next month. We're taking a break for the summer, so enjoy the time away. And we hope that all of you can join us back here in September for more great conversations.
Thank you so much. This was a great conversation. Thanks a lot for having us.
Thank you very much.
Thank you. Have a nice day or night.
Next September.
Bye bye. Gracias a todos. Chao.